Hi guys, welcome to week 5 of business law. Welcome to week 5 of CLAW2214. We are going to be finishing up contract law, so finishing up contract law and more so about content and the contract rather than the background of the contract. So last week we talked about the background surrounding a contract, whether it is an invitation to treat or actually a contract, whether or not some person is under duress and what how to establish a contract. You have to be intentions to create legal relationships. You have to have a consideration in exchange for something. You can't be doing a unilateral service or based on your pre-existing duties and whatnot. So here in week 2 of contract law, so actually this is week 5 of Clause 2214, we're going into the content of contract law. So let me minimize my screen and go into the content itself. So before we go into the PowerPoint slides, let's just quickly look at what we are going through now. So here we are at week 5, going over contract and contract law. And then we're going to go into Australian consumer law protections, so freedom to contract in the future, and IP law, which is a little bit easier. But the bulk of it is still in contract and contract law here in week 5, which is what we are going to be going into. So let's get into that. So contract law today about content and of the contract. So terms of the contract refers to the what is encapsulated when parties have agreed to a certain contract. When a party agrees to a contract, they agree to the terms within the contract. These contracts terms could either be express or implied. Express means it is unambiguous and it is written. Implied would be implied through laws and applied through the language that is presented. And it is very hard to prove something is implied because in most cases, if the authors have thought about it, they then should have written it down. So if you have implied terms, it would be a better idea to write it down because it is unambiguous and agreed upon by the parties when they sign. So the meanings could be determined and it is clear in writing as opposed to implied. So just know that they're implied contract terms, in most cases implied through law and statutes, not explicitly written in the contract by the parties. For example, if I'm selling my phone, then it is implied that my phone is functional and that it works, and it's not implied that it is not broken. Express terms are clauses within written contracts. Parties are bound by the terms upon the signing or upon the effective date. Parole evidence suggests that is the rule that only the evidence granted within the contract is enforceable. So usually, and other implied terms, the terms recorded in the contract and the exclusive basis of the parties' rights and obligations. So only what is included within the contract has rights and obligations. Everything else does not. So this shows that the general rule is subject to certain exemptions. To remove uncertainties, parties can include an entire agreement clause. This is also called the four corners clause because once again, on a piece of A4 paper, there are four corners. What it says is basically you are only required to do what is written within the contract. What is not written within these four corners are not enforceable. So this is the idea that this agreement, this is an example of a rather aggressive removal of uncertainty, where everything else, where the contract is entirety is final and complete and fully integrated, rather than having additional evidences that could be provided. Express terms or contract terms that may be mere representations. So once a representation is the sales talk before you sign a contract. So it is marketing, it is what goes on before you sign the contract. So representation is in relation to oral statements made during negotiation of the contract as necessary to distinguish representation between the contract. Because what you sign is what you agree on, but what you sign is not what you agree on orally. Because what you sign is signing to agree on the contract that is written on the paper rather than the oral agreement, which could be considered as representation. So this distinction is important because you may have agreed on something different, but however, when it comes to the contract in writing, it is slightly different. Perhaps there are certain terms that are removed or certain terms that are added. Therefore, it is only the signed document within the four corners rule within that removes uncertainty that is enforceable. Representation usually is not enforceable. So what is the difference and distinguishing between terms and representation and misrepresentation? So the intention to pre-contractual statements may or may not be terms. Most cases they are not if you have the four corners test to protect your basis. Courts also, when interpreting contracts and interpreting representation, would use the objective test. So what would a hypothetical person, this person does not exist, what would be a hypothetical, reasonable, well-informed person think within this scenario? So courts often use this example as well. Relevant factors to consider also includes the importance of a statement if it is a crucial piece of puzzle within the contract during a representation. However, it is not included during signing. Perhaps courts would use the reasonable person objective test to lean towards the defendant or the person being harmed. Time between statement and the contract, if there is a 6-month discussion period, which is considered representation, a 6-month discussion period, and then a final contract, and within one of the discussion periods somebody said something, it may not be as proportionally relevant. Then we have special knowledge or skills. If it's very highly specialized, then potentially representation would be important because people are not informed. So therefore, this is why the reasonable person test or the objective test is important. The court and the judge specifically would consider what a reasonable person that is fully informed would think about certain situations. Here's an example. You can pause it and read it. So a parole evidence rule is the idea that it limits additional evidences that parties could bring towards a dispute. So this is the idea that only what is signed is enforceable. And all the additional, so we could have previously agreed to other contracts, other terms. However, what is enforceable within this contract is only what's on the paper. Okay, so that's the idea of parole evidence rule. It limits the evidence that a contract party can introduce during being sued or suing when trying to determine the specific terms of a written contract. So here we have some examples here, but it is the idea that only what is written down within the contract document is enforceable. Everything else is evidence, but it is admissible. It's not evidence that could be used when a dispute or when a altercation occurs. The entire agreement of four corners clause, that's what I mentioned, A4 paper has four corners. This is the idea, an entire agreement clause is the idea that the entire, this piece of contract is the entire agreement between these two people. For example, if I have a contract between you and me selling my phone, and nowhere does it say I have to provide a charger, and then you cannot come back and sue me that I did not provide a charger, because in the contract it only says my phone and my phone case, for example. So that's the idea of the entire agreement clause, which protects the seller or protects the person from additional recoups of benefits or additional recoups of services, because only what is included within the contract is enforceable. So the purpose of this is to provide certainty and clarity as to what is being offered and what it is being offered for. It protects users from potential risks that could arise if there is misleading interpretations or implied terms that certain parties did not consider. Once again, the burden of proof is quite high, if almost impossible if you have the four corners test in existence. Implied terms, we mentioned how contracts have express and implied terms. Implied terms are used to fill the gaps that a common sense, and once again we talked about a fully rational, hypothetical, informed person, a reasonable person would have concerning a case. So implied terms are usually due to legislation and laws. They could be a fact of business and efficacy as to result in the course of dealing by parties. Usually these must be necessary for business to function efficiently. Covered by usage or custom or usage. So here's an example. Here, if you buy a toaster from JB Hi-Fi, it is implied that the toaster works and could toast bread, rather than just being a decorative paperweight or whatever. Implied statutes and laws. Okay, so we are going to have in week 6 an entire week about the Australian consumer laws. However, here in week 5, we just basically introduce Australian consumer laws, mandatory guarantees. So this conflicts with your freedom to contract. So as in democracies, Australia, for example, we have freedom in common law countries. We have freedom to contract. I could, as a fully informed adult, I could enter into contract with other people. I could enter contracts into businesses without hindrance and approval from governments. However, there are certain things that I cannot contract about. For example, I cannot employ people under minimum wage. That's a law that forbids me from signing contracts with employees if I am the employer under minimum wage, because that is illegal. So Australian consumer laws also ensures that consumers, because there is an imbalance of power. We have these massive corporations like Arnott's, they make biscuits, Tim Tams for example, and here we have a lowly Joe. He is just a random bloke from Tasmania or whatever who's trying to get some Tim Tams. There is a power imbalance, and in order for protect the consumers here in Australia, the ACL, the Australian Consumer Laws, outlines mandatory guidelines. For example, goods should be of acceptable quality to fit the purpose, to be finished, to be free from defects, to be safe, and to be durable. So these are laws that would prevent and curtail your certain abilities to contract. We're gonna have an entire week, so you don't have to think too much about to be too worried about this. So exclusion clauses, you could, in addition to to saying what you want to include within a clause, you could also explicitly exclude certain items or exclude certain situations from occurring. So this is what exclusionary clauses are. They seek to restrict the right of a party. One of the common ones are non-competes. For example, when you are employed at a certain accounting firm, you are not allowed to work for a competitor or for a client. I mean, this is an exclusionary clause on what you could do, so it limits the right of a party. However, we can understand why employers and accounting companies may want to restrict the ability for their employees to work for competitors. There is also, for example, hush clauses where you can or non-disclosure clauses, which would limit your ability to perform certain rights. So incorporation or exclusion clauses. So this is an example of that. Jurisdictional interpretation and exclusion clauses, limitations, defects, misrepresentation, duress, unconscionable harm. So these are aspects that would make a contract void. So if you misrepresent, if you have a mistake, you have duress. Duress is me holding a gun, threatening you to sign the contract. Unconscionable conduct, that is immoral or unfair conduct, as described by a court. So this is hard to prove. Contracts to restraint of trade or other illegality, such as against the Australian Consumer Laws, the ACL, would cause defects within the contract. So these are just the clauses. So ending a contract, that is how you end a contract. All right, so this is week 5's content. I do hope that you took something away from it. It is very interesting, and there certainly is a lot to learn here. So pause the videos, the slides that I have went through, and without further ado, thank you for coming along. Take care and goodbye.